Morning, everybody. A friend of mine just reminded me that Walter suggested all week that you all wallow in curiosity. So are you wallowing in curiosity? That's what I want to know. All right. Okay, because today is another day of really fantastic talks across a lot of subjects, from genetic science to moral thinking. Very interesting talk coming up at lunch about trust, which is not exactly going to be happy, but something we need to understand. A wonderful discussion about foundations of the future at lunch. Just lots of stuff going on today. So please just go to things you don't know anything about. I'm going to take no time to make introductions because I think you're all here for a reason. I think the notion of understanding what law is about and the rule of law couldn't be more important. So it's my pleasure to introduce Jeff Stone, a professor at the University of Chicago Law School, former acting Solicitor General Neil Katyal, and former acting Attorney General Sally Yates. Thank you so much.
So before we begin the discussion, it's worth saying just a word about the idea of the rule of law. The concept of the rule of law goes back a long way. The Greeks and the Romans talked about it. Its meaning has evolved over time. But what it eventually has come to mean is basically a fundamental way in which a society prevents the situation in which there is an oligarchy, autocracy, or dictatorship. And internationally today, the understanding is that it has several requirements. The first, and no doubt most important, is that government officials and their agents are accountable under the rule of law. That's absolutely critical. Second is that laws are protective of the fundamental rights of citizens, including, among others, the rights of freedom of speech and freedom of press. A third is that laws are made in an open and public manner and that they are fair-minded. And the fourth is that the enforcement of laws is done by independent tribunals, by adjudicators who are capable and are independent of the forces that be. And so with that background, I'd like to sort of begin by asking our commentators to talk a little bit, before we turn to some of the more immediate issues, about their experiences and perspective on these issues drawn from some of their backgrounds. So Neil is one of the nation's leading Supreme Court advocates. He's argued 34 cases before the Supreme Court of the United States. And one of those involved the Guantanamo detainees and the case of Hamdan versus Rumsfeld. And so Neil, if you could talk a little bit about that experience and how that illuminates the idea of the rule of law.
Great, thank you. It's an honor to be here with both of you, and Sally, you're our hero, so thank you for being here. So that was my very first case, and I'd come into the Clinton administration, and I was National Security Advisor to the Justice Department there, and I just loved it, and I thought my dream job would be one day to be National Security Advisor to the president. And I taught constitutional law, and my students would always tease me and say, you think whatever the president does is constitutional, you're such a hawk on these issues. And then on November 13th, 2001, I was watching CNN right after, a couple months after the nation had been horribly attacked, and I saw that ticker at the bottom, that news ticker that they had gone to, and it said, President issues military trial order for suspected terrorists at Guantanamo Bay. And I thought, that's interesting. In Clinton, we tried to do that after the embassy bombings, but we concluded it was absolutely unconstitutional. So how is he doing it? And then I looked at this order that the president had issued, and it had the same flat violations of everything you just heard Jeff talk about, things like no accountability, not an independent tribunal. President Bush was handpicking everyone for these tribunals and essentially creating a legal black hole at Guantanamo. And so I thought to myself, I should really try and bring a case. I'd never really litigated much before, not certainly out in front, but I started working with the JAG attorneys, and we created a test case, and I represented bin Laden's driver. And I had argued the case in the district court, and for 10 months I was trying to meet him, bin Laden's driver, try and go to Gitmo. And at first, the Justice Department said, oh, you have no security clearances. You don't have any ability to go. I said, look me up. I got more clearances than you'd ever heard of. And so they look at it, and they're like, oh, yeah, it turns out you do. But then they said, you have no need to know. So you have the requisite level of clearance, but you don't really need to do this. They said, you're a law professor. You can make these arguments, and you don't have to actually meet your client. They're theoretical constitutional arguments. And I'm such a deferentialist to the government. At first, I thought, well, that's kind of right. I could make these arguments. No, wait a minute. It's his case. He's the client, the driver. I should get to meet him. So I asked for that in writing. And then they let me go to Gitmo right away because they knew I was going to give it to the New York Times if they barred me from meeting my client. So I go to Gitmo, and the story's almost over here, and I'll wrap up. But I go to Gitmo, and the Pentagon was really savvy about this. They made it a 30-hour trip for me. It takes 3 hours, when they do it, the prosecutors. But they made it 30 hours. I had to fly around the island of Cuba and all sorts of stuff. But eventually, I get there after 30 hours, and I meet my client for the first time, Mr. Hamdan. And he looks at me. He kicks the military attorneys out of the room. He says, everyone has to leave except for you and the translator. And I think he's going to yell at me. He'd been in solitary confinement for 10 months. He had not seen a human face for 10 months. Foods passed through him through a slot. Anytime there was a face, they were wearing a mask. Our CIA manuals say you do this to someone for 3 days, and it causes permanent psychosis. So 10 months. So I think he's going to yell at me. And he gives me a smile, and he just says, why are you doing this? Why are you representing me? Your last client was Al Gore. That didn't turn out so well. Why are you doing this? And I paused for 40 seconds when he asks me that. And I remember in my head thinking to myself, this is why you should just be a law professor, Neil. You can't answer a simple question. What kind of lawyer are you? And then another 5 seconds passes in my head, and I think to myself, maybe it's okay. Justice Ginsburg, when you ask her a question, she'll often pause for up to a minute before answering it. So maybe I'm okay. And then another 5 seconds passes, and I think, well, it doesn't matter. He doesn't know who the hell Justice Ginsburg is.
And no wonder it took 40 seconds if he's doing it all.
But then I told him this, and this is the answer to your question, Jeff. Sorry for the long lead up. But I said, look, my parents came here to America from India. They came here not because of the quality of its sports teams or the quality of its soil. They came here for a simple idea, that they could land on its shores and their kids and them would be treated fairly. Maybe not perfectly, but fairly compared to any other nation on earth. And I told this driver that was always my experience, having the best schools, opportunities in the government, to be in the Deputy Attorney General's office, all sorts of things. And that when the president issued this order, for the first time in American history, a president had said, if you are one of the 5 billion foreigners or the 12 million green card holders like my parents, and you're accused of a crime, you get sent to Gitmo. But if you're a US citizen, you get the Cadillac version of justice, the American civilian trial. That had never been done in American history. We've never drawn such a distinction. And I said, that's why I'm doing this. I didn't tell him this, but I'll say to you, the words of the Equal Protection Clause of the 14th Amendment say equal protection to all persons, not to citizens. Why? Because Representative Bingham, who wrote the 14th Amendment, said we need to overrule the worst line in the worst Supreme Court case in American history, the line in Dred Scott versus Sanford, which said only citizens have constitutional rights. So to me, that's what the hallmark of the rule of law is, those things that Jeff mentioned, but also I'd add equality to that. And that is what I think we need to fight for in the days to come.
If I can add just one thing to that is, I actually wrote an amicus curiae brief in the Supreme Court in the Hamdan case representing Fred Korematsu. Fred Korematsu was the party in the Japanese internment case in the Supreme Court from almost 60 years earlier, in which the Supreme Court upheld the internment of Japanese Americans during World War II. And it was important that Korematsu he actually wanted to be a party to this, to make his voice heard in this case. Sally Yates is, I think some of you have heard of her. Sally served 27 years in the Department of Justice, first as an assistant U.S. attorney, then as United States attorney for the Northern District of Georgia. In that capacity, she litigated a wide range of cases, including issues involving political corruption and terrorism. In 2015, President Obama appointed Sally to be Deputy Attorney General of the United States. During her confirmation hearings, I love this fact, then Senator Jeff Sessions asked Sally if she would refuse to enforce a president's unlawful orders, referring at the time, of course, to President Barack Obama's, quote, unlawful orders, to which she replied that she would have an obligation in all circumstances to follow the law and the Constitution, a commitment that she later had an opportunity to fulfill. So Sally, on this initial point, perhaps you can talk a bit about the historic independence of the Department of Justice.
Well, when Jeff went through and outlined some of the principles underlying the rule of law, really at the core for the Department of Justice is the concept of the equal application of the laws, that the law is to be applied impartially. That's why Lady Justice has the blindfold on, that it applies to the rich and the poor, the weak and the powerful, exactly the same, and that the Department of Justice should not be making its decisions based on any kind of outside influence, particularly not political influence, that the laws can't be used or should not be used to punish your political enemies or to protect your political friends. And these are concepts that aren't actually law. I mean, this is not provided in the Constitution per se. It's not a statute. It's really part of the fabric of the rule of law that has developed through the norms over the years. And this was really driven home to me back just shortly after I became U.S. Attorney. And all of the U.S. attorneys went to the White House for what was really a photo op with the president. And we're all lined up, all bright-eyed and bushy-tailed and excited about our new charge. And the president comes in and one of his aides had given him talking points to read to us, which he promptly, tossed aside. And he looked at us and he said, "I appointed you, but you don't represent me. You represent the people of the United States." And he was absolutely right. But the fact of the matter is that wasn't a particularly bold statement. That's a concept, a time-honored concept at the Department of Justice of drawing a line between DOJ and the White House. And DOJ is really different than any of the other federal agencies. The Department of Justice is obviously part of an administration, but there absolutely has to be an independence and a separation from that. And that's been a time-honored concept through Democratic and Republican administrations, at least going back sort of in the post-Nixon world. And I think actually that DOJ is the only agency that has a written memo that lays out what the rules are for contacts between the White House and the Department of Justice on specific cases. Not necessarily on policies, because of course the Department of Justice will be involved in policy decisions, but on specific cases. And the rules that are still in effect right now, that Eric Holder's last memo was 2009, are that really there are only two people at the Department of Justice that the White House can contact, and that's the Attorney General or the Deputy Attorney General. And there are only three people that you're supposed to be contacting at the White House. That's the President, the Vice President, or the White House counsel, or his or her deputy. And again, Eric's memo was the last one, but this has been a tradition of the department going back administrations. And I think that it's absolutely essential that that tradition be protected, not just to ensure that decisions are not politically impacted, but that there's not the appearance of that, because merely with the appearance of it, I think that can destroy the public's confidence in the fairness and impartiality of the Department of Justice. And if the public loses confidence in its own criminal justice system, then we're in a world of hurt. So there's my long-winded, rambling answer.
Not at all long-winded.
Yeah.
So both of these individuals have been involved in different but important ways in the travel ban issue. And I want to turn our attention to that. Neil, by the way, represents the state of Hawaii in that case in the Supreme Court. And Sally, of course, was involved in the Department of Justice there. And so, Sally, I'd like to begin with you. How did you get involved in this? What were your views? Why did you hold the views you did? Why did you do what you did? Yeah. And were you surprised by what happened?
Yes, to all of that. Well, I'll try to make this brief because I don't want to hog the whole thing here. I got involved in this. It was Friday evening, late afternoon. I was in the car on the way to the airport on Friday, January 27th. And I had actually just finished a meeting at the White House on what's now known on the Mike Flynn situation. And I was in the car going back for an event honoring my husband the next night. I got a call from my principal deputy. During the time that I was holdover as acting attorney general, I was able to keep one of my assistants that had been there before, and the rest of the political appointees are Trump appointees at this point. And so it's about 5 o'clock or so, between 5 and 6, and Matt calls me and says, "You're not going to believe this, but I was just on the New York Times website, and it looks like the president has instituted some sort of travel ban." That's how we found out about it at the Department of Justice. Read about it on the internet. Well, I'm on my way to the plane. I've got my iPad. I'm furiously going on there trying to figure out what it is. I go ahead and get on the flight to go back to Atlanta. Happily, we had Wi-Fi, so I'm literally going online to try to find a copy of the executive order so we could get some sense of what this was. And so over the course of that weekend, it was a whole lot of trying to figure out what the heck is this thing and to whom does it apply? Because at the time that I made my decision, it was the first executive order, not the second one that Neil is litigating now. And at that time, we were getting conflicting signals, but when the music stopped, the White House told us that yes, it applied to LPRs, lawful permanent residents, people with green cards. They would not be allowed to come back into the country even though they had legal status here. It applied to people with visas. So we spent most of the weekend trying to figure out sort of what is this and what are they trying to accomplish here. And over the course of the weekend, the very next morning, we had to have people in court defending actions that had been filed by various plaintiffs around the country. And so until we could get a handle of what this was and whether we thought it was lawful, my instructions were you can defend on procedural grounds, meaning if a case has been mooted out because someone is admitted, you can defend on procedural grounds, but we're not going to take a position on the constitutionality until we have a chance to actually figure out whether we think this is constitutional. So come Monday morning, I learned that the next day we are going to have to take a position on whether it's constitutional. So we gathered all of the folks who were involved in this at the Justice Department in my conference room, and that included the Trump administration appointees as well as the DOJ career people, civil division people and otherwise, that were involved in this litigation. And I had gone through, this is all happening so fast. I'm literally going online to find briefs and challenges to see what the challenges are to the travel ban. And we went around the table with my asking them, all right, tell me why you think this is lawful. How are we going to defend this? And without revealing sort of our internal discussions here, at the end of that, I was not comfortable that it was in fact lawful or constitutional and kept the senior Trump appointee back to tell him that I was very uneasy with where we were and that I wasn't sure what I was going to do. And then went back in my office and thought about it more and talked with a few people and came ultimately to the conclusion that our defending this travel ban would require me to send lawyers of the Department of Justice into court to say that this ban had nothing to do with religion. It was all based on national security, nothing to do with religion. And I did not believe that to be a defense that was grounded in truth. And I couldn't send Department of Justice lawyers in to defend something based on a defense that I did not believe was grounded in truth, which then left the dilemma of, okay, so do you just resign at this point then, or do you direct the department not to defend the travel ban? And I confess to you, this is again all happening in a very compressed period of time. This is Monday afternoon now. I went back and forth on that. There's certainly an argument, and I understand that some people think that I should have just resigned. But sort of the bottom line on that is that I didn't feel like I would be doing my job if I just essentially said, I'm out of here. You guys figure this out. It's up to you to go in there and to make a defense that at least we were not comfortable was grounded in truth, but at least I won't be part of it. That would have protected my personal integrity, but I didn't believe that it would have protected the integrity of the Department of Justice, and it wouldn't have been doing my job. So I issued a directive to the Department of Justice, unless and until I was convinced that it was lawful, that the Department of Justice would not defend the travel ban. That was late in the afternoon, and not surprisingly, I got a memo, or actually a letter, about 9 o'clock that night. firing me. So that was that.
Are you aware of other situations where an attorney general or acting attorney general refused to obey the orders of the president?
You know, I'm not, but this was a very unusual situation in that I learned in the course of this that our Office of Legal Counsel had been instructed not to tell me about the work on the travel ban until after it was over and until after the president had executed it. And so normally, what you would have would be a process in this kind of situation where if there's a national security reason to do something, you would confer with the national security agencies before doing it, and you would also confer with the national security experts at the Department of Justice who are going to have to defend it. And that would include the people in our National Security Division and our Civil Division who ultimately did have to defend this. There was none of that consultation at all, not even notification at all. So I'm not aware of another situation like where the Attorney General has done that, but I'm also not aware of a factual situation like this before either.
The analogy I was actually thinking of was of course, the Saturday Night Massacre,
Right.
Where Elliot Richardson...
Sorry, you threw a softball for me over the plate and I missed it.
did.
Sorry.
Yes, but just to remind anyone who's forgotten that Elliot Richardson and William Ruckelshaus, the Attorney General and Deputy Attorney General, both refused to comply with President Nixon's order that he fire a special prosecutor, Archibald Cox. But that was the one that occurred to me. And they, of course, took the choice of resigning and rather than simply disobeying and waiting to be fired, which they would have been, of course. So Neil, as I mentioned, is representing the state of Hawaii in this case and in the Supreme Court. So why don't you talk a bit about your experience with the case and what's happening and what's going to happen and all that cool stuff.
Okay, sure. And maybe before doing that, I just want to situate Sally's remarks within the role of the Justice Department. When you're the Solicitor General or sometimes the Attorney General, you have two kind of traditions which are not about zealously advocating for winning cases, but to do justice. And those two traditions are that you decline to defend something if you believe it is obviously unconstitutional, or you confess error in a case in which you won in the Court of Appeals and you think you shouldn't have. So every Solicitor General, I did this and my Republican and Democratic predecessors did, they go to the Supreme Court and say, Supreme Court, that case that we won, we should have lost. So please grant this case, hear it, hear argument, and rule against the Justice Department. I don't think there's a better way of underscoring what Sally's initial remarks were about the role of the Justice Department in terms of being the public's lawyer, not the administration's lawyer, than that. And so I think Sally's, when she did what she did on Monday, she was hearkening back to, I think, the best traditions of what the department is about. And resignation doesn't preserve that set of objections. It doesn't explain your reasons. So I'm glad that you wrote the letter that you did. Now, after that letter was written, various folks had these lawsuits, including the state of Washington, over the first executive order and after they won in the district court, President Trump, called them a so-called judge, the judge who ruled against it, and so on. It then went to the Court of Appeals and was unanimously struck down there as well. The president then pulled back, issued a new executive order a month later, and that new executive order is very much like the first executive order, except it has 6 countries covered. Iraq is now not covered instead of 7. It has a more extensive description of when someone can apply for a waiver, and it says in there that green card holders are now not covered. It tried to provide some facts because in the Court of Appeals argument over the first executive order, the administration lawyer was constantly being asked by the judges, what national security justification do you have? And there was, as Sally said, nothing in the first executive order. In the second, they spent a month and they came up with 2 things. One, that 2 citizens from Iraq had come to the United States and engaged in terrorism. They forgot that they exempted Iraq from the new executive order. And second, that a Somali child had come at the age of 2 as a refugee and grew up and committed an act of terror. Of course, they forgot that they were exempting children from parts of the executive order too through the waiver provision. So, and plus the idea that we're going to like bar refugees who are 2 years old who need to be here on humanitarian grounds because one day, 20 years later, they might go out and do something. Well, that just strikes me as not really where the country probably is on this set of issues. So in any event, after the first executive order was issued, I represent the state of Hawaii on all their Supreme Court matters, or a good chunk of them, and I started talking to that team, including the Attorney General of Hawaii, Doug Chin, who is an astounding individual who carries, I think, the best traditions of justice that Sally exemplifies to the state of Hawaii, and we decided to bring a challenge. And at that point, there were other challenges in the system, and others went first. But for the second executive order, we were ready to go. We thought it was virtually the same. We filed the lawsuit right away and blocked it from going into effect on the day it was supposed to go into effect, March 15th. Then argued it in the Court of Appeals on May 15th, last month. This is probably the most unusual oral argument I've ever had because it was live carried on all the news networks. Normally, like Supreme Court arguments, there are no cameras at all. And so it did change, I think, a bit the dynamics of the argument, but also so cool for the public to be able to see this. I mean, and people all over the world to see a full argument. Won it in the Court of Appeals, I guess last week, feels like, maybe 2 weeks ago. And then yesterday we had a Supreme Court decision on this, and the details, it's a complicated decision. They've set the case for argument in the fall, so we'll argue it in the first or second week of October. But they did cut back a little bit on the injunction that the district court had issued in our case. The district court had said no travel ban, that is, no, the 6 countries, people from the 6 countries who were blocked from coming in, they said all of them could come in, plus the refugee ban, the block on refugees for 120 days, that was also something that the president couldn't do because, as Sally was saying, this was motivated by religion, and that's basically what the president campaigned on. He said, I think Islam hates us. I'm calling for a complete and total shutdown of all Muslim immigration. Even when he signs the first executive order, he reads the title, looks up at the camera and says, we all know what that means. And there were a whole bunch of other things that the president has done while president to reinforce the idea that this is truly a Muslim ban. So what the Supreme Court yesterday said is, that's absolutely fine, the challenge, we're going to let it stand for people who have some connection to the United States. So a refugee who's sponsored by a church group who's made contacts, or a University of Hawaii student who's coming, or we also represent the imam in the largest mosque in Honolulu who has a mother-in-law from Syria. All those people and people like them are fine, which is effectively actually everyone who is going to come in the 90 and 120-day period. So the president declared victory yesterday, and I guess it's a victory compared to his resounding 100% losses up until now in every other court. But if those are the kinds of victories the president has, I hope he has more of them. Because at the end of the day, it's a 6-3 decision yesterday from the United States Supreme Court saying the vast, vast bulk of the Muslim ban, the refugee ban, the travel ban cannot go into effect until they hear argument in October. And I am not aware of another instance in the United States history in which a president in his first 150 days has been told by the courts, you can't do something that you claim you need on national security grounds. I mean, that is an astounding thing to happen in the first 150 days and underscores why this panel is so important, because we are seeing an unprecedented threat to the rule of law by this president. And I don't think it's a Republican issue or a Democrat issue. This is just a pure constitutional civics issue.
If a central part of the issue here is the role of religion in an unconstitutional manner in the formulation of the ban, why does the court distinguish between these two parts of the ban? Either of you.
So I don't think the courts distinguish between the refugee and travel provisions with respect to its effect on the denigration of Muslims. I think the court so far has treated them the same, and indeed even the Supreme Court yesterday treated them the same. And our challenge basically saying this is all motivated by anti-Muslim sentiment. I mean, at this point, the vast, vast majority of refugees coming in are Muslim refugees. That hasn't always been true, but it is true now. And I think what the courts have been concerned about, when you think back to the grand First Amendment, Congress, and the executive shall have no establishment of religion. I think, the founders were really worried about using immigration to try and create a religious state. Indeed, Virginia had done precisely that by barring Catholics, for example, from coming in through the immigration laws. And Madison's remonstrance in 1785 is in part about this. And it is our American tradition that you come on its shores, we don't care who you pray to, and we're going to treat you fairly. And this president has done something very different by saying, well, everyone else can come, but not if you're from one of these Muslim countries, which 90% to 99% Muslim. That is a very scary thing for the rule of law.
So 3 justices took a different view. Who were they, and what were they thinking?
So Justice Thomas yesterday wrote a separate opinion that said that he thought that the entire ban should go into effect, that there wasn't a likelihood of success on the merits. And I don't know if that's what President Trump was referring to when he declared a unanimous victory, but that was, of course, 3 justices, Justices Thomas, Alito, and Gorsuch. Pointedly, the Chief Justice and Justice Kennedy did not join that opinion. But certainly, I think it's fair to say that at least those 3 justices have signaled that they think the administration is on a stronger legal footing than certainly the lower courts have.
So to take a more general view of this, Sally, what threats do you see today to the rule of law in our nation?
Well, Neil alluded to some of President Trump's comments about judges. And I think it's not just that the president is making comments undermining the legitimacy of judges who issue opinions that he doesn't like. It's what kind of impact can that have beyond just his own, espousing his own personal opinions in undermining confidence in the system more broadly? I mean, we have got a delicate balance there between the 3 branches of government. And, that balance has served us pretty darn well for many, many years now. And the idea that that balance is being thrown out of kilter by not just disagreeing with what a court might do, but attempting to delegitimize it. That seems very different to me than the kind of, not just rhetoric, but feelings that seems to evoke in the public. And it concerns me that can be really destructive and can be further divisive, as if it seems like we can't get much more divided in some ways right now. But that's obviously not in the long-term interest of our country either.
Neil?
If you think about it, the judiciaries are our crown jewel. I remember when I won that first Gitmo case, the first argument I did, and I went out on the courthouse steps, and I said this briefly yesterday at the talk that Jeff and I did, there's 500 cameras out there, and they're asking, what does the decision mean? What does it say? And nobody had read it yet because it was so long, but I said to them on the steps, here's what it means. It means that in America, you could have this guy who's accused of being the lowest of the low, the worst guy ever, the driver to bin Laden, and he sues not just anyone, but the nation's most powerful, the world's most powerful man, the President of the United States, and he brings his case not in rinky-dink traffic court, but in the highest court of the land, the Supreme Court of the United States, and he wins. That's something remarkable about our system. Our founders knew that our government was going to make mistakes. Our presidents were going to make mistakes. As Madison says in Federalist 1501, men aren't angels. That's why government's necessary. And they lace that into the system. And now you have a president who says, no. I get to make the rules. He wants actually to kick these travel ban cases out of the court altogether. He thinks that actually, he filed a brief, I've never seen this before in my lifetime, a brief in the Court of Appeals saying the mere fact that the court is even hearing the challenge undermines our national security. This is a ludicrous proposition. Bush and Cheney at their darkest day never said anything like that. And then to undermine, as Sally says, the authority of them to even pronounce anything, to call them so-called judges and things like that. I can't imagine something more corrosive to our American democracy and our system of checks and balances than a president who takes these kinds of views. I mean, you think about the things the court's done, Brown versus Board of Education, all sorts of good things the court has done in moderating the worst excesses of democracy, and then to have a president who says, no, I know better. I mean, I don't think we've ever had a president who knew better than our system.
By the way, I should tell you that we'll move to questions from the audience in 5 or 6 minutes, so you should be thinking about questions you might want to ask. What does this tell us about Justice Gorsuch?
Well, I would imagine President Trump is pretty pleased with his nominee at this point, but I don't think we should be terribly surprised by it. I mean, I think this is consistent with where he was. But look, this is a couple of opinions. We got to give the guy a chance here. So I think that we should sit back and see sort of how it all plays out. And this is just at the injunction stage as well. But I think everyone should have expected that Justice Gorsuch was going to be a conservative judge. And I wouldn't think that this would come as any great surprise. Neil may have a different view, but that's...
So look, I mean, Justice Gorsuch has been on the court a whopping 2 months at this point. I think it's important to let the process unfold, even in this case, which after all has been set for argument in the fall. I did take a position on him in his confirmation hearings and did support him on the grounds that I was very upset when Republicans voted against our Democratic nominees, Justices Kagan and Sotomayor, who I thought were extraordinarily qualified and would be great. And I felt like the same yardstick should apply to the other side. We're only a couple months in. I supported the Chief Justice's confirmation, and I remember getting attacked similarly at the summer after his first term. Oh, he always voted doctrinaire, conservative, never voted against party line, and so on. But I think we've seen the Chief Justice really move into a very different position on the court, casting the deciding vote to save, for example, Obamacare and things like that. So I think, let's wait and see. I don't think it's, I think we got a lot of time with Justice Gorsuch on the court. I think we just have to wait.
So a primary concern many people have about Gorsuch being on the court is how he got there. And on this notion of rule of law, is what the Republicans in the Senate did to Chief Judge Merrick Garland in his nomination, because Sally mentioned rule of law doesn't always mean just law in a narrow sense, but norms and conventions. Is the refusal of the Senate Republicans to consider or indeed to confirm Merrick Garland consistent with the rule of law in this way?
Well, I think you wrote a column or two on this.
Yes, I did.
Yeah. You want to answer your own question?
No. I'm the moderator. I'm supposed to be moderate.
Well, consistent with the rule of law. I mean, it's certainly not consistent with how we have operated as a country or how I think we ought to operate. I mean, certainly it was troubling to me that President Obama didn't get an opportunity to be able to even get a hearing for his nominee, much less to be able to make the appointment. It's not like your last year in office is forfeited, whether that is a violation of the concept of the rule of law or not, I don't know, but it's not how we ought to be operating.
Merrick Garland was the most qualified nominee, not just in our lifetimes, but perhaps in the history of the U.S. Supreme Court. The chief judge of the D.C. Circuit for 20 years, our nation's second highest court, never once been overruled by the court in his 20 years as Supreme Court. I mean, he was extraordinary. And so it was unforgivable and a really sad thing for our system.
So what do you think has brought us to this point? Is it simply the election of Donald Trump or other things going on in our society and in politics that combine with that to create a real danger to the rule of law?
Well, I do think that there is a kind of up for grabs nature about truth and law right now. Maybe it's engendered by social media. That's something that you had mentioned yesterday, Jeff. But there is this kind of view that there is no law out there anymore. It's all just politics. And at least those of us old-fashioned people, it was actually more of a conservative idea when I was in law school. There actually is a law out there, and there's a text, and there's intentions, and those things mean something, and they constrain judicial decisions. And we're seeing that break down. And it's actually broken down far more on the conservative side. I mean, and so you have the Supreme Court time and again striking down things that President Obama did on grounds that are, as far as I can tell, just made up because it's raw politics and power that they've been able to engage in at times. And so it's certainly something the left had played in the Warren Court as well. So I don't mean to say that one side's innocent to this, but the result is really we don't have a stable consensus on law today in the way that I think we did at earlier points in our history.
What about the issue of political polarization? To what extent has that contributed to the challenge to the rule of law? The notion that there's an increasing division in the society where people are less trusting of one another and of government as a sort of entity that will look out for the well-being of the larger society. Is that contributing to this, do you think?
I mean, it seems that we're in the midst of a toxic swirl of sorts. When Neil mentioned, the issue of the truth and facts, it seems sometimes that the facts will be thrown out there. They're demonstrably untrue. It's established they're untrue, and we just move on the next day to the next story. And there are no consequences for that. We just seem to move on, and it's almost as if we have to keep kicking the rhetoric up to be able to get folks, when I say we as a country, have to keep kicking the rhetoric up to be able to get people's attention. And it's like the lid's about to blow off, that there are no limits anymore in terms of what you can say or claim. And that just starts throwing all of those norms out the window that have really governed not just how we litigated, but how we operated as a society as well. And I don't know if that is contributing to the polarization or if the polarization is contributing to that phenomena, or maybe they're sort of feeding on each other. I'm not sure.
One of the things Neil said earlier is that the framers were very concerned about trust and separation of powers and having judicial review was all designed to deal with the risks of bad behavior within government. And one of the questions now is, are we at a point where the protections against that bad behavior are breaking down? And to the extent that's true, that's a real threat to the democracy and to the future. Okay, so let's invite some questions from the audience. There are two people with microphones, so how about over here first? You can get that over there. Is that possible?
So my question is for both of you. It's for Mr. Katyal and I assume I'm pronouncing that correctly. I apologize if I'm not. Mr. Katyal and Ms. Yates. My name is Felix De Simone. I'm from the Bezos Scholars Program. And first of all, let me just say that it is an honor to have you here. Personally, the story of Ms. Yates' firing was the very first story that really made me spit out my my covfefe, if you will, and say, wow. And Mr. Katyal's fight against the travel ban really helped cement my faith in the justice system of the United States in the face of this dilemma. And as a result, I think I think many of us here view both of you as among the great leaders of this era. So thank you for being here. So my question is fairly simple, straightforward, and it regards the I word, which is, of course, impeachment. And there have been calls since day one of this administration for impeachment, and frankly, I don't think that they had very much legitimacy at first. However, I think that's changed. From Trump's firing of Ms. Yates, to his firing of Comey, to, God forbid, his potential firing of Robert Mueller, it is increasingly clear that there is a case to be made for the obstruction of justice. And one can imagine that, for instance, if President Obama had done the same thing, people like McConnell and Ryan would have already constructed and began impeachment proceedings. I think many of us think that President Trump has already well crossed the threshold of constitutionality, but the majority of the House and Senate clearly do not agree. So my question is there a tipping point similar to, say, a modern-day Saturday Night Massacre, at which point the House and Senate Republicans will jump ship and join the call for impeachment? And if so, what is this tipping point?
Have fun.
Well, as a country, yes, I would assume that there is a tipping point. I wouldn't presume to know what that might be. But, you know, one of the things that's concerned me a little bit, as folks have talked about the special counsel investigation that's going on now that Bob Mueller is doing, you know, I know Bob Mueller, and folks ought to have tremendous confidence in him. I mean, he is the consummate professional. He is going to call it like he sees it. He's going to do this the right way. But Bob Mueller is going to be deciding whether or not crimes were committed that then could be used for prosecution or for impeachment. Surely that's not our bar. I mean, that's not the standard of conduct that we're looking for from our president or our administration. I mean, it shouldn't just be whether you committed a felony or not. It should also be whether or not you're observing the kind of norms that we've been talking about here today that are so essential to really the fabric of the rule of law. And so while I have total confidence in Bob Mueller and his ability to conduct this investigation, I don't think that we should just be putting all of our hopes in, well, that'll tell us whether anything bad happened here, because there's potential, and I don't know what the facts are, so I'm not drawing conclusions about what he may ultimately determine, but you know, there are facts here that should be alarming to us as a country that falls short of facts that would establish a basis for impeachment or for prosecution. Yeah.
I can't improve on that.
Yeah.
I would say, by the way, that the Republicans will come to that view if and when they determine that it is clearly in their political self-interest to do so, and not otherwise. Yes, over here.
Hi, two questions. One, a lot of what you said has to do with the integrity of the Department of Justice. If over the next 4 years, people like Neil Katyal and Sally Yates don't want to work at the Department of Justice, what does it look like in 4 years? So that's one question. And the second is, Sally, you wrote a fantastic opinion piece in the Wall Street Journal about criminal justice reform this week or last week, and I would love to hear you expand your comments on that.
Well, do you want to, well, first of all, I would say with respect to the Department of Justice, look, I was there for 27 years. I have total confidence in the career men and women who are at the Department of Justice. I mean, you all should feel really good about the folks who have committed their professional lives to doing the work of DOJ. Now, granted, absolutely, and those are the folks who are doing the real nuts and bolts work there. So granted, political appointees, like I became a political appointee, they set the policy and the direction of the department, but you have got thousands and thousands of career DOJ people that are there that care deeply about the mission and the integrity of the Department of Justice. And I put my confidence in them. And there are also good Trump appointees that are at the Department of Justice now as well. So I don't think all is lost for DOJ. It's going to withstand in anything like that. With respect to the second question on the op-ed, I would take all of your time here. Sort of in a nutshell, the gist of this was Attorney General Sessions had written an opinion piece saying that justifying going back to the mandatory minimums of the 80s and 90s that we had, saying that Attorney General Holder's smart on crime policy, where we took a more measured use of mandatory minimums, that was what was responsible for the increase in violent crime that some cities have experienced across the country, even though some cities have also experienced decreases, and that if we don't go back to locking drug dealers up for as long as we can, then I'm obviously paraphrasing here, the country is going to be overtaken by violent crime. I just think that is a totally wrong-headed approach, both from a fiscal standpoint and importantly from a public safety standpoint, that it is not the best use of our public safety dollars, that there's really absolutely zero evidence that keeping drug dealers, nonviolent, low-level drug dealers in prison for longer is going to reduce violent crime. In fact, the data is just the opposite of that, and that we need to be taking a more holistic approach to that. So, and it was in the Washington Post this past weekend.
And if you haven't read it, I strongly recommend it, by the way. It's terrific. Over here.
Hi, I'm Emma Greene. I'm a journalist with The Atlantic magazine. For Sally Yates, first a question. Do you believe that Mike Flynn will be offered an immunity deal from Bob Mueller, and what factors should he weigh in considering such a deal? And then second, for the full panel, what would be illegal about collusion between the Trump campaign or administration in advance of or following the election if such collusion did exist?
Well, I'm going to tick that over to you guys because I don't think I should be telling Bob Mueller how he should go about doing his investigation. So I'm going to defer on whether Mike Flynn should be given immunity or not.
Do you have a view?
Yep.
I don't have. Sorry. Over here.
I'm a physician from Atlanta, Georgia, and I had to take the Hippocratic Oath. What is the significance of the oath of office for our president and our vice president?
Well, it is actually, in the Constitution itself, and I think put in there in order to reinforce the obligation the president has to take care that the laws be faithfully executed. And I think folks need to worry about that right now. There's no question. I did want to pick up on something Sally had said about the professionalism of the department and marry it to something that Jeff had said about Korematsu, because I think it illustrates really the traditions of government lawyering. So when I was running the Solicitor General's office over the summer, the Supreme Court's not sitting, and so you have a little extra time. And so I'd remembered in college, I'd read something about how the government might have lied to the Supreme Court in the Japanese internment cases. So I pulled all the briefs and everything in the correspondence and started reading it. And it was really remarkable. There were two line attorneys, career attorneys, John Burling and Edward Ennis, who were assigned to write the briefs defending the Japanese internment. And they realized the entire theory of the defense was just lies. There was actually a report by the Office of Naval Intelligence saying this is all prejudicial, not motivated by any security threat whatsoever. There was, the Army had justified it on, well, basically Japanese Americans were going to the coastline and signaling to submarines offshore about our troop movements and critical infrastructure. The FCC had investigated that and found totally bunk. J. Edgar Hoover, no fan of civil liberties, thought that the Japanese internment wasn't justified. All of this was suppressed by the administration, by FDR. And so these two lawyers said, we're not going to sign this brief. You're suppressing evidence. The Solicitor General ultimately overruled them and said, I'm filing the brief. 15 pages of facts on how Japanese Americans can't be trusted. And it was a real dark day, I think. But I think that story illustrates one thing that you see time and again at the department, which is the career folks standing up, trying to do the right thing. And it's the political folks who come sometimes and say, no, we're not going to do the right thing.
Back there.
Sally, has Ted Cruz offered to provide you a reference? No?
Yes.
I'm Don Brodsky. I'm a practicing lawyer from Houston. Could you all discuss the process for filling all the vacancies in U.S. attorneys around the country, and also whether the vetting process for federal judicial vacancies is likely to provide qualified candidates in the future?
I know how the process worked in the Obama administration, but I don't know how it's working in the Trump administration. So you all, yeah.
It doesn't seem to be working. But I will say a little bit about the judge side. I actually have been quite impressed with the Trump nominees to the courts of appeals. They, look, I mean, I suspected they'd put Judge Judy up, but so I'm kind of happy, but actually some of the most qualified people in my generation, certainly conservative, but I think reasonable, smart, very accomplished individuals. So that's one, I think, bright spot that we've seen. I don't know anything about the few U.S. attorneys that they've nominated. I can certainly tell you they've gotten rid of some extraordinary ones like Preet Bharara.
Back here.
Ms. Yates, it's not clear you have a lot of fans, not just in the tent, but across the country. And I was wondering what your future holds and if elected office might be in the cards for you.
I appreciate that, and people have been incredibly nice and generous, but I don't really see running for office. I'm not entirely sure what I'm going to do next. I'm taking some time with my family now and starting to talk to some folks, and I want to be able to find an avenue where I can continue to have an impact on issues that I care about. But running for office has just never been anything that I've really could picture myself doing.
And if I could just say something about being a department employee in 2 different administrations. I mean, I don't think a year ago, if I saw Sally, we would have predicted that she would have been seen as the kind of political hero that she is now. I mean, she was known as the consummate Justice Department pro. No idea about politics or anything like that. That's what she was known for. And it was the circumstances, these horrible circumstances she was put through from Friday to Monday, which have, almost, we've lost a little sight of just how many amazing, just non-political, awesome things Sally Yates did for the United States Justice Department and for our country.
So if the rule of law is under attack by the president and his administration, what's next? Is there a multi-pronged approach and strategy? Obviously, we're all very well aware of Bob Mueller's investigation, but are there other attempts on trying to right these wrongs?
I think there's two important pieces to this. One is the defensive piece, a litigation strategy that's designed to make sure that the worst excesses of the president are reined in. So the ACLU's doing some of that. There's other organizations doing it. I think that's real important. The other thing, we haven't talked about it yet, but is the press. I mean, you think about all the amazing stories the press has done since November, and I understand there's a lot of heartburn about the press before, but I think it really does underscore, when our founders thought about checks and balances, they did think about division of powers, horizontally and structurally, federalism and separation of powers, but they also thought about this First Amendment, this idea that the press was going to keep our executive and our Congress on its toes and report. And I mean, it has been breathtaking, what we've been seeing. So I think supporting journalism is supporting the Constitution of the United States.
And following up on that, I want to say that one of the things that's impressed me enormously in this time is that traditionally very conservative journalists and commentators, including people like George Will and David Brooks, have been terrific at being willing to call this administration in a range of areas where I would not have personally expected that. And I think they deserve a lot of credit for doing that. But the other thing I think about this is ultimately a lot will depend on the Republicans who control the House and Senate. Whether they at some point actually step up and meet their constitutional responsibilities and obligations to look out for the best interests of our nation rather than operating as political operatives. And I think that's central to the success of a democracy. And at the moment, we're not seeing that. Yes, over here. Yeah, right here.
Could you comment on the abolition of cameras and sometimes audio in Spicer's press conferences?
Saves us from having to listen to it? I don't know.
But what's it going to do to Saturday Night Live now?
Right. Yes, over here. You got it.
Yes. Given what you just said about, and we assume that everybody who's in Washington is working for the best interest of the country, do you think Mitch McConnell, in the things that he is doing, is working for the interest of the people?
It's a no-brainer.
So I've been really disappointed. Our founders obviously didn't anticipate political parties when they thought about checks and balances. And so that has contributed, I think, to a large number of the problems here. As the gentleman before was saying in his question, I mean, if the Democrats did even one billionth of what, telling Russians about the Israeli spy and all that, any part of this, there would be impeachment proceedings before, within a millisecond. So I do think that there is a real problem, a real double standard going on here. and it is a threat to our constitutional democracy. There's no question about it.
Over here.
Hi, good morning. I teach at a school in San Diego with a fairly sizable Muslim population, and thank you for helping me understand the Supreme Court's decision yesterday. But I'm wondering if there's anything else you might want me to share with my students to help them understand the Supreme Court's recent decision.
I guess I'd like you to share with them that hundreds of members of Congress have said this isn't who we are. I guess I'd like you to share with them our 167 biggest technology companies have said this isn't who we are, that dozens of our top national security administration officials from both parties, people like Hayden and people like that, have said this is not who we are. That this president doesn't speak for what our constitutional values have been and what they will be.
If and when they prove Russian collusion with the election to the point of impacting the election, what happens in the rule of law? I mean, if Trump gets impeached because of something related to that is one thing, but isn't Pence fruit of the poison tree? And what would happen? What happens to the laws that Trump has signed and the Supreme Court and all that?
We have like 15 seconds, so. Sorry.
I think only law professors could answer that question.
Yep.
So the laws are still going to be in effect, even there's a presumption of regularity behind those things, unless they could be shown to be the taint of the specific collusion or anything like that, should anything ever be shown. So, in terms of Pence, I suspect that they've tried to wall him off. I mean, if you've seen House of Cards, you know how this plays out. But I think he's presumably walled off from these other things just in case there's a problem.
So Neil and Sally represent the best of our nation. They should be models for others who are in government and in the private sector to live up to the rule of law and to protect our Constitution. Thank you all very much.